Assalamualaikum dan salam sejahtera. Firstly, let me thank Intan for inviting me to attend this colloquium. My name is Dr. Salahuddin bin Shariff, currently attached to the Ministry of Entrepreneurial Development and Cooperatives, or MIDEC, and I've been invited to give a talk on my topic from my thesis, which is the best interest of the child principle. I hope that I will be able to convince all today on the importance of this principle and the reasons why I actually endeavored to do a research in this topic. These are the contents of my paper. I will not be going through all of them, but I've made references here so that for the ease of everybody, all the participants to read. Okay, my thesis was rather straightforward. However, as in all researches, the actual title proved very elusive. So at the end of the day, after much discussion with my supervisor, we ended with basically one of my problem statements as the title of my thesis, which is as follows, and I've summed it up into the best interest of the child principle. Again, I will not read for the interest of time. Right, the problem statement. I chose this topic for several reasons. It was during my tenure at the Ministry of Women, Family and Community Development that I identified that the Child Act 2001 was not the idealistic act that it was portrayed to be. The act was supposed to fulfill Malaysia's obligations and commitments under the Conventions of the Rights of the Child, or abbreviated to be called CRC. The CRC is a human rights instrument under the auspices of the United Nations. As with any law, the usual benchmark for Malaysia has always been England specifically, or UK, and this is similar for the Child Act. Malaysia actually sent a team of government officers and NGOs to England to do research on the English Children's Act way back in 1998. The Convention on the Rights of the Child, CRC, must be complied by all state parties. To do this, each state party must submit a country report once every 5 years. To date, Malaysia has only submitted one country report. Even that, there were several recommendations, or actually suggestions, made by the CRC committee, the committee that is actually in charge of monitoring a state party's compliance to the convention. The thesis focuses on one specific recommendation, and the recommendation states as follows. Again, I will have to read this one because it's quite important. As regards to Article 3, Paragraph 1 of the Convention, the committee emphasizes that the Convention is indivisible, that its articles are interdependent, and the best interest of the child is a general principle of relevance to the implementation of the whole Convention. The state party should ensure that the best interest of the child is a primary concern, taken into account in all revisions of legislation, as well as in judicial and administrative decisions, and in projects, programs and services that have an impact on children. Note the salient features of this recommendation. Firstly, that the principle is of general relevance to the entire convention. Secondly, that the state to ensure that the principle is a primary concern, and thirdly, on all revisions of legislation, as well as in judicial and administrative decisions, and in projects, programs and services that have an impact on children. This is a direct recommendation on the government, and not only on the judiciary, but the government policies on children. This is my thesis statement. Implementing the best interest of the child principle as stated in the CRC and the CRC committee would require Malaysia to implement the principle, balancing the application as pronounced in the CRC with that of the Sharia law and the civil law in Malaysia. General information on the CRC. The CRC is based on 4 core principles. These core or guiding principles of the CRC can be found in Articles 2, 3, 6 and 12. If I put it in a diagram form, Article 2 speaks of the non-discrimination on all children, Article 3 on the best interest of the child, Article 6 on the survival and development of a child, and Article 12 is on participation. I will only speak on the main principle, which is the best interest. What is the principle? According to the CRC, it is in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be a primary consideration. Emphasis I added myself. And this is the main crux of the research, the CRC provision, as compared to the UK provision under Section 1 of the Children's Act of 1989, entitled Welfare of the Child, subsection 1. When a court determines any question with respect to the upbringing of a child or the administration of a child's property or the application of any income arising from it, the child's welfare shall be the court's paramount consideration. Note the difference in the threshold. In Malaysia, it is not as universal. I will not state it specifically which provisions, but in Malaysia, the application, the best interest of the child is mentioned in 13 different sections of the Act. The list is provided. Now let's go on towards the conceptual framework of this research, which is purely based on the principle I mentioned earlier, the best interest of the child. The Child Act was Malaysia's response to incorporate the principles of the CRC into Malaysian law. The CRC, like all international human rights instruments, is a rights-based convention providing for child rights. Now, briefly, a rights-based convention or law is a law which has no penalties or punishments within that particular law. The best example I can give for Malaysia is our federal constitution or the Persons with Disabilities Act. Both provides rights but no penalties or even punishments in those particular provisions of law. The best interest of the child principle is also incorporated in this Act. This thesis is a study of whether the current standards of the best interest of the child principle in Malaysia fulfills her obligation under the CRC. The research will analyze the principle as applied in England and how it compares to the CRC as well as in Malaysia. This would include the English and Malaysian civil law under the relevant acts and courts, the international law, the CRC, and the Islamic law or the Sharia law. Briefly, my research methodology is purely qualitative, as in most legal researches. The research utilizes a doctrinal and black letter law approach, since the data for analysis were documents and articles on the CRC, the Children Act of 1989, and the Child Act of 2001, as well as case law from both jurisdictions. The research methodology chosen is a comparative study of England and Malaysia because of the strong historical and legal relationship between both these jurisdictions. Initially, the research thought that the best model would be that of the English legal system or English principle. However, the findings were quite surprising. The research identified that the best interest of the child principle, as envisioned under the CRC, does not share the same threshold as the principle in England. The populist theory was that the CRC and the English model were the same. However, based on my research, the threshold of the principle in England is higher than that set in the CRC. The principle in the CRC was evidently more acceptable than once thought. The initial threshold, as envisioned by the English legal system, proved the problem for many Muslim states, and Malaysia included, because of its adherence to Sharia law. This thesis also showed that the best interest of the child principle, as envisioned under the CRC, is actually closer to the Sharia approach, and Malaysia should utilize it as a means to move forward and apply the best interest of the child principle as required under the CRC to fulfill her obligations. As in any research, challenges are expected, similarly in this one. Although next explicitly mentioned, Malaysia practices legal pluralism. Legal pluralism is the practice or application of more than one legal system. Malaysia applies common law in our courts, but we have written law which is slightly different than the common law. We also have in the field of personal law, the Sharia law, which is applied to the majority of citizens in Malaysia, the Muslims. These two legal jurisprudences have almost no common ground. Other challenges includes literature, which is voluminous in England and lacking in Malaysia. In Malaysia, the only source of civil law cases, which only cover a smaller part of the people in Malaysia. The literature on Islamic law or Sharia law is in a language other than Arabic is very scarce, and the lack of uniform Sharia laws in Malaysia among each of the states and in the world, generally in the different schools of thought, is also a challenge. Now comes the big why. After the Second World War, the United Nations was formed to foster greater cooperation among states and less conflict. It also developed the Universal Declaration of Human Rights and later the International Bill of Rights. All these ideals were based on certain rights that are inalienable to humans. These rights were later developed into the Human Rights Scheme. Under this, several other conventions were established, and amongst them was the CRC. The CRC was open for signing in 1989. Malaysia acceded to the CRC on the 17th of February 1995. Now, ratification and accessions to human rights treaties are expected in the international legal fraternity, and Malaysia is under considerable diplomatic pressure, if I may, to further improve over its human rights record. Malaysia has the lowest number of ratification or accessions in all the Southeast Asian countries on human rights treaties, only 3 out of 9. So Malaysia definitely has to improve her human rights records. I will skip the next 2 slides and leave it for all of you to read. I'll go straight to the findings and implications on the relevant government policies. Within my research, I found that currently there is no harmonized approach in applying this principle. As stated earlier, Malaysia has 3 separate branches of law. Statutes or written law as seen in the Child Act. Secondly, the common law as practiced in Malaysia's civil law courts through case law. And thirdly, Sharia law, which although enacted in the state legislatures, is also expounded through the Sharia courts. Generally, the principle is expressed in the Child Act, but not as complete as required in the CRC. The Child Act 2001 needs to be amended to incorporate a more holistic approach in applying the principle. The English Children's Act of 1989, notwithstanding the higher threshold, has provided a method of universal application of the principle throughout the whole country and all aspects of life and policies for a child. The difference clearly in Malaysia is that in the Malaysian Child Act, the best interest of the child principle are only used when the specific section is invoked, whereas in England, based on this definition of within the Act, it is applied universally in all matters regarding children. KPWKM, as the lead agency on policies for children, must strive as follows. Firstly, amend the Child Act 2001 to provide a similar provision like the English Children's Act of 1989, however, with a more acceptable threshold that based on the CRC and more Sharia compliant. Secondly, engage all states in Malaysia to amend the respective Sharia family law enactments to standardize and harmonize their law so that the practice is uniform throughout Malaysia. There must also be strong policy direction by the government towards this objective. Once the laws have been amended and harmonized, the principle will be applied uniformly. Until that happens, Malaysia will not be able to fulfill her CRC obligations. With that, I thank you.